Hello, it's Philip Taylor speaking from Richmond Green Chambers. I'm looking at a memoir which Oxford University Press have published. It's this book here. It's by a judge called Albie Sachs, and the book is called The Strange Alchemy of Life and Law. Very interesting front cover, which is a picture actually of a painting by a lady called Judith Mason. And in fact the history of the picture is actually given in the book itself. And the title of the photograph is The Man Who Sang and the Woman Who Kept Silent. And it's in memory of two people who were killed, Phillip and Harold Safola, both of whom were killed. And it's explained in some detail, and it very much sums up, for me in any event, this particular memoir and what it contains. Now, I've written this memoir. There's a review of it on Flickr and all the main internet sites where the book appears, and I'm permitted to actually post up comments. I've written this with my wife Elizabeth as a review, and we talked about the book, and we've given it the title Unexpected Ways, Pre- and Post-Apartheid, ALBIES Insider Perspective. And let me start off by saying that if you love justice as much as you abhor and detest injustice, you'll be deeply moved, in our view, by this engrossing 300-page jurisprudential memoir, as I've described it, by Albie Sachs. The same is true, of course, for judges, who, in the words of our former Lord Chief Justice, Lord Woolf, believe judging is much more than merely deciding cases. Yes, this is one of the few entertaining, if I can put it that way, books which can be classified as a work on judicial reasoning and how a judge might decide from the insider perspective. I'm not talking too much about concepts like American realism here, which is too deep for this review, but you'll get a flavour of what Sachs is actually talking about in this very moving account of really what he's been doing with his life. Therefore, every judge should be encouraged to read it, we say, and that actually is echoed, of course, by Lord Woolf, who says, quote, "I'm sure it would improve their understanding of what the job really involves and what justice is about." And I know the late Lord Taylor, the Lord Chief Justice, a while ago, would certainly have echoed that comment. Sachs is a doughty and courageous fighter in the struggle for justice in South Africa under the malevolent and apartheid regime which made the country a world pariah. Following the release of Mandela in 1994, and who can forget that day, Sachs played an important role in drafting South Africa's post-apartheid constitution, and was appointed by Nelson as a member of its first constitutional court. With the startling lucidity which characterises his writing, Sachs reveals what it was like to be a judge in circumstances which are particularly unique, especially in view of the fact that he himself was a victim of apartheid. As an advocate at the Cape Bar from the age of 21, he defended people charged under racist statutes and repressive security laws, incurring the wrath of the authorities. He was subjected to banning orders, placed in solitary confinement for 2 spells of detention, and exiled in 1966. After working for some 20 years in the UK and Mozambique, he was seriously injured by a bomb. Now, as his term on the Constitutional Court nears its end, Albie Sachs has decided to look back on his extraordinary life, writing with passion and insight about the ways in which his experiences have influenced his judicial approach and his views on the nature of justice. And I think that's actually quite an important concept for anybody who's looking at jurisprudence and the way that judges arrive at decisions. They're all human, when we make these sorts of decisions, you know, we're going to come at it from different angles. So, when one has suffered oneself under an irrational and oppressive regime, including detention and torture, one's personal and judicial outlook will inevitably be influenced accordingly. It was one of the worst moments of my life, recalls Sachs, describing a particularly appalling incident of torture. It was not a hypothetical situation of the kind that some academics conjure up when discussing the costs and benefits of the government using torture. He comments, and he then goes on to say, the practice was systematic. It was organised, it was condoned, it was part of policy. How many times have we heard that in other territories and other jurisdictions in the last few hundred years? Rather too many. Policymakers worldwide, even in the enlightened democracies, who've been tempted to believe that there are pros as well as cons which justify torture in whatever form, should read this powerful and enlightening book. And how do life experiences affect legal decision making, asks Sachs in his preface. The answer, he concludes, is in unexpected ways. Yes, so therefore we can conclude that this is a book for the jurisprudent, and great for students and legal philosophers alike in the 21st century, and I'm proud to have it in my bookcase. Thank you very much. Bye-bye.